So I'm now going to give the floor to Marie-Arena to give her analysis of the process of adopting the conflict minerals regulation. Now that we're at the end, have we been able to find an agreement between the parties? Have you had any questions during the negotiations? And do you have any lessons are there any lessons to learn from this process? We had exactly the same discussions as in French law, and neither did we succeed in this legislation in enforcing the question of sanctions exactly in the same way. That's to say, we were able to go towards what was obligatory, mandatory, with a lot of timidity insofar as we had obtained in the European Parliament to have it obligatory concerning the whole of the chain, that's to say from the minerals right up to the finished product, which for us was the guarantee that we would no longer have any disloyal competition, because if you have a requirement in Europe about what is produced in Europe, and if you don't have the same requirement for what is produced elsewhere but comes into Europe, then that is in actual fact a disloyal competition between products produced in Europe and those produced outside. But of course the corporate world isn't afraid of disloyal competition. I felt this more than all the liberals in the company. For me, to be a liberal is the guarantee that there is loyal competition between the various productions, and that's my conception of liberalism, economic liberalism at all events. But I didn't meet any liberals as liberal as that. They said we're going to demand for things in Europe, but we're not going to actually demand for things that come in to Europe that are produced elsewhere. They're further than I am in this liberalism. So that's the problem of my interlocutors. So we know so we came up against the same problem. At the end of the process? Well, I'd rather say we're at the beginning of it. We obtained, we got some legislation which was a halfway legislation. We got an obligation on part of the production chain with our interlocutors who were against anything being mandatory. They said, oh, don't worry, all the rest is it's just going to follow suit. And it's a question of the market laws. The market's going to follow. So I have a few doubts about the market following. Because we have experience in that area of the market not following. We said that after 2 years of applying this, we're going to assess the way in which the market will be following. And if the market follows, then we won't change the law. But if the market doesn't follow, then within 2 years, legislation has to be made mandatory throughout all along the chain. And now if anyone is in the production chain, I would encourage you to get the market to follow, because 2 years after it enters into application, I hope Parliament will be able to go along that lines of that obligation. We will plead for this legislation to be obligatory along the whole chain of production, and you can see what the French came up against as far as resistance from the from the member states. We got this resistance, and it shows that democracies are more or less the same, whether it's on the national level or at the European level. Or those who say that Europe has less democracy at the national level, I think we have exactly the same reality on the national level and on the European level.
Nele. So we've heard now sort of about what's been happening at the EU level. We've heard a little bit what's happened in France, but there are other models to explore. Do you mind just talking to us a little bit about what those models can look like?
So the question is, how can due diligence actually be in the legislative context? So you could roughly group legal models in 4 groups. So the one group would actually be you have a legislation to impose a human rights due diligence obligation onto companies. Often this is linked to a liability as well. So, you have 2 recent examples. It's for one, the French law. On the other hand, the conflict minerals regulation. The 2 differ in that sense that, for instance, the French law is put in a civil law context. That means actually it's a judiciary authority that will ensure the enforcement. On the other hand, the conflict minerals regulation, it's an administrative regulation. There you have authorities actually checking on companies whether they carry out due diligence or not. And this has obviously, it's a question of implementation and where would you see the resources. Then another option approach to prompt a business to carry out due diligence is actually to define a liability and to allow companies actually to use due diligence as a defense. So, for instance, all the common and civil law regimes in the EU know the damage, the possibility of claiming damages in the context of negligence, and negligence is actually defined as an unreasonable behavior that caused damage. And so, for instance, if there's a damage caused by the company can actually then excuse or defend itself by showing that it carried out due diligence. A third group is actually the group where states encourage due diligence by requiring reporting on the due diligence processes. So you have it in the context of the non-financial reporting directive that has been mentioned, or the UK Modern Anti-Slavery Act, where companies are asked to report about their due diligence policy, about the risks they have identified, and it depends on the regulation. They might also be asked about the mitigation measures. However, there is no obligation actually to mitigate or to improve the due diligence processes in case they are not effective. And the last approach would be that states actually give incentives or benefits to companies who carry out due diligence. So you have that, for instance, in public procurement policies. So in the context of the conflict minerals, the Commission committed to give preference to companies that actually carried out due diligence in their mineral supply chains. You have it also in various export credit regimes, that only those companies will receive investment support that actually can show that they have carried out due diligence on the impacts of their products. And there are many more examples, but Paige is already looking at me.